Usually when we talk about a regulatory framework, there's this expectation of precision.
Right, like engineering.
Yeah, exactly. Like you break a rule, the compliance X-ray shows the jagged white line, and the regulator just points and says, there it is, there's the breach.
Well, that is the traditional comfort of the job, isn't it? It's binary, regulated or unregulated, in scope or out of scope.
But I'm looking at the stack of sources we have for today's briefing, the finalized FCA policy statements, High Court judicial review documents, Upper Tribunal filings, and that X-ray machine is just, well, it's completely broken.
Yeah, it really is.
We are looking at a regulatory landscape where the central authority is actually hitting its absolute limits. I mean, we're seeing boundaries being awkwardly redrawn, enforcement being entirely outsourced, and some, frankly, spectacular turf wars between regulators themselves.
It is a profound shift. We're moving from a period of regulatory expansion into this period of diagnostic muddy waters, really, where the regulator has to face the reality of what it can actually control.
Welcome back to Reg Talk UK, the podcast that helps UK banking professionals stay sharp, stay informed, and stay ahead of regulation. I'm Alex.
And I'm Jamie.
Today, we are bringing you a deep dive into the limits of regulatory power in the UK. We're untangling the FCA's finalized crypto rulebook, where the regulator has made a rather stunning admission about its own capabilities.
Quite an admission, yeah.
We'll unpack why the Upper Tribunal has completely frozen the FCA's £9 billion motor finance redress scheme. We'll look at the FCA's strategic forced retreat on the consumer duty for wholesale markets. And finally, we'll explore a landmark High Court ruling that just smacked down the Financial Ombudsman Service.
With the FCA itself actually intervening against its own complaints handler.
Right. A structural crisis across 4 different fronts.
Absolutely.
Let's start with the crypto frontier, because the FCA has just published its finalized 5-part rulebook. So that's policy statements 269 through 2613.
Which fully applies in October 2027.
Yes, though there is a planned consultation in September 2026 for a 6-month deferral, just to prevent a cliff edge for legacy tokens. But the headline here isn't the timeline, is it?
No, not at all.
It's the FCA explicitly admitting that a centralized surveillance role over crypto is, and I quote, impractical and ineffective.
Which is just a remarkable thing for a statutory regulator to actually put in print.
I read that and immediately thought, are they just waving a white flag here? I mean, they are essentially saying, because of the global 247 nature of crypto liquidity, we physically cannot monitor this market.
So they passed the buck.
Exactly. They say, so the UK qualifying crypto asset trading platforms, the QCATPs, you have to do it. To me, this is like the police telling a nightclub owner, look, we can't monitor the dance floor, so you're the cops now. You halt the trading, offboard the suspicious actors, manage the asymmetries.
Well, I wouldn't call it a white flag per se. It is certainly an admission of defeat regarding traditional centralized TradFi surveillance, where the FCA watches the London Stock Exchange from a central dashboard.
Right? But it's actually a highly pragmatic, if brutal, tactical move. The FCA is prioritizing operational reality over regulatory hubris here.
How so?
By passing the surveillance bill to the private sector, they're leveraging the fact that these platforms have the internal real-time visibility over their own order flows that the FCA will just never have.
But the cost of that pragmatism is entirely borne by the industry. I mean, the updated cost-benefit analysis puts the total sector cost at £230.3 million.
It's massive.
Familiarization costs alone are £15,000 just to read and digest the new framework.
That is the point, though. They are intentionally creating a massive barrier to entry. The FCA is betting on the halo effect.
Explain that for us.
If you make the UK the hardest, most expensive, most rigorously policed jurisdiction for crypto compliance, you theoretically weed out the bad actors straight away. And then you attract serious institutional capital that wants a safe harbor. Okay, let's talk about how that policing actually works in practice. Because I'm looking at this £10 million threshold for what they call a large QCATP, and it seems, well, completely arbitrary to me.
Yeah, a lot of people feel that way.
If a platform has over £10 million in average global revenue over 3 years, and yes, they held firm on global revenue, not UK revenue, they face heightened duties. But one of those duties is on-chain monitoring of link wallets.
Yep.
Hold on. Blockchains are pseudo-anonymous by design. How exactly is a platform supposed to monitor external linked wallets on-chain?
That is the £230 million question, isn't it? The mechanism here requires an incredible level of technological sophistication. A platform can't just look at its own internal ledger anymore.
Oh, no.
To identify a linked wallet, they have to use off-platform telemetry. They have to scrape IP addresses, analyze withdrawal patterns, and look at external blockchain forensics to see if a customer is moving funds to a secondary unhosted wallet.
Right, and then using that wallet to manipulate prices on a decentralized exchange.
Precisely. They're hunting for specific market abuse mechanics. They're hunting for wash trading, where an entity simultaneously buys and sells the same asset to create a false illusion of market activity.
So faking liquidity, basically.
Exactly. And they're looking for pump and dump schemes where coordinated actors inflate a token's price before selling off. The FCA realized that if they demanded platforms monitor the entire global blockchain, it would just boil the ocean.
Right, it's impossible.
So narrowing the scope to linked wallets gives platforms a fighting chance.
It's still a massive ask. To go back to my nightclub analogy, that isn't just asking the owner to police the dance floor. That's mandating the bouncers follow patrons out the door and, monitor what they're drinking at the bar down the street.
Yeah, especially because these platforms now have to share cross-platform intelligence with competing venues if they suspect abuse.
Wow.
And monitor for price dislocations, material differences in token prices between their venue and external markets.
Before we move on, I want to clarify one more technical hurdle from these policy statements, which is the disclosures. The FCA completely scrapped the fungibility exception.
They did.
My understanding was that if a token is fundamentally the same, meaning it's fungible or interchangeable with a token already trading a platform, wouldn't need to write a brand new qualifying crypto asset disclosure document, a QCDD.
That was the hope, yeah.
But now, every single asset admission requires a unique document. Why? If a Bitcoin is a Bitcoin, why do we need thousands of separate disclosures?
Because in the FCA's eyes, the mechanism of delivery changes the risk profile entirely. A direct Layer 1 Bitcoin is fundamentally different from a wrapped Bitcoin on the Ethereum network, which carries smart contract vulnerabilities and, bridge risks.
I see.
The FCA doesn't want different technical risk profiles being obscured under a single generic disclosure umbrella. Every token needs its own asset-specific transparency.
Which means if you're a platform hosting hundreds of legacy tokens right now, you are desperately hoping that September 2026 deferral consultation grants you a grace period.
Oh, absolutely.
Otherwise, you are staring down an administrative nightmare, trying to generate unique, compliant QCDDs for every single asset by October 2027.
It forces the industry to grow up overnight.
So we have the FCA actively handing over the keys in crypto because they recognize they can't police the perimeter. But what happens when the regulator does try to wield absolute centralized power over a massive market issue?
It seems they hit a brick wall.
Which brings us to the complete paralysis of the motor finance sector.
The £9 billion elephant in the room.
Indeed. The Upper Tribunal has just partially suspended the FCA's motor finance redress scheme. This is the massive investigation into historical discretionary commission arrangements, where lenders allowed brokers and car dealers to adjust interest rates to increase their own commission. Right. Lenders were put on the hook for an estimated £9.1 billion. The legal challenge freezing this up is being driven by the captive lenders. So that's Volkswagen Financial Services, Mercedes-Benz Financial Services, Credit Agricole Auto Finance, alongside Consumer Voice.
And if you're managing operations or compliance at a lender right now, the mechanical implications of this suspension are incredibly significant.
Right, because the tribunal hearings are now pushed all the way to December 2026, or possibly February 2027.
Yes.
Until they rule, lenders are exempt from calculating redress, paying it out, or even issuing formal rejections to customers based on manufacturer ties. But I want to dig into the strategy here, Jamie. Let's look at the strategy here. The captive lenders are fighting tooth and nail, but the major high street banks, who have massive exposure, aren't challenging the scheme at all.
No, they're not.
Lloyd's Banking Group set aside £2 billion. Santander raised provisions to $640 million. Why the divergence? Why are the captives fighting while the high street banks are quietly provisioning?
It comes down to fundamentally different funding structures and business models. High street banks like Lloyd's use retail deposits to fund a massive, diverse portfolio of loans, mortgages, credit cards, personal loans.
Sure.
For them, taking a £2 billion hit on historical car loans is painful, obviously, but prolonged litigation damages consumer trust across their entire retail banking brand. They want to draw a line under historical conduct issues and move on.
Cut their losses. But for a captive lender,
A captive lender is the financial arm of the car manufacturer itself. They don't have retail deposits. They use wholesale funding specifically to move metal off the forecourt.
Right, the cars themselves.
Their entire historical business model was deeply intertwined with incentivizing the dealer network through those discretionary commissions. For a captive lender, this isn't just a discrete conduct issue. A ruling against discretionary commission fundamentally breaks their core historical revenue engine.
That explains the severity of their legal arguments then. They aren't just arguing over the redress math. They are fighting on limitation periods and human rights grounds, specifically property rights under the Human Rights Act.
Exactly.
They're arguing that forcing them to pay massive, retrospective redress is unlawful interference with their property.
And this exposes the fundamental fragility of industry-wide regulatory remediation. The FCA is trying to use a centralized mechanism to force blanket compensation.
Yeah.
If the captive lenders win on these property rights grounds, it could permanently destroy how the FCA approaches historical misconduct. It removes their biggest stick.
And the FCA knows it's a massive gamble.
Right.
They admitted that if the scheme is quashed by the tribunal, compensation could slip to 2028 or beyond.
If it happens at all.
Right. Alternatively, they might just dissolve the scheme and force lenders to resolve complaints individually under the standard 8-week timeline.
Which would be an operational disaster for everyone involved. It would dump a massive, completely unmanageable backlog straight onto the Financial Ombudsman Service.
The FOS.
Yeah, the FOS is already having to make contingency plans for a significant uplift in complex cases if this centralized scheme collapses. Firms have to keep preparing for the scheme in the background. Supervised pragmatism, the FCA calls it, but they don't have to pay out.
This brings us to another area where centralized, one-size-fits-all regulation is actively fracturing. We've talked about the consumer duty on this briefing for years. It was billed as this overarching cultural shift for the entire financial sector.
It was.
But under CP 2623, the FCA is officially refining the consumer duty to remove business for genuinely non-UK customers from its scope, specifically targeting wholesale markets.
Providing much-needed relief for wholesale firms who have been, frankly, tearing their hair out trying to prove a retail duty doesn't apply to them.
Simon Walls, the FCA Executive Director of Markets, literally came out and said the duty was, quote, never intended to become a wholesale duty imposing on deals between sophisticated parties.
A bit of a backtrack.
I have to be honest, it is incredibly ironic. They launched this massive framework, and now they are having to awkwardly walk it back. It is exactly like mandating child-proof caps on medicine, which makes perfect sense for a household,
Right.
and then realizing you accidentally applied the exact same legal requirement to a commercial chemical plant.
That analogy actually holds up perfectly when you look at the mechanics of the market. What we are seeing here is the FCA recognizing that applying retail asymmetries to wholesale markets was actively destroying the UK's competitiveness as a global financial center.
Unpack that. How does the duty actually cause friction on a trading floor?
Well, think about an activity like market making. A market maker provides liquidity by constantly quoting buy and sell prices for a complex derivative.
Okay.
The counterparties buying those derivatives are hedge funds, institutional investors, or large corporations hedging currency risk. They are highly sophisticated counterparties. They negotiate intensely, they contract, they allocate capital, and they manage their own risk.
I don't need the FCA holding their hand.
Precisely. They do not need the FCA dictating whether a bespoke, multi-million-pound derivative contract provides fair value in the same way a retail customer needs protection on a basic current account.
It's just a different world.
The legal asymmetry inherent in the consumer duty, where the firm holds all the responsibility for the client's ultimate outcome, it simply doesn't compute when both parties are institutional giants.
So what this means for you, if you are operating in the wholesale space, is that there are finally clearer boundaries. The FCA is clarifying that activities like market making, custody, and safeguarding are generally out of scope.
Provided you don't genuinely shape downstream retail consumer outcomes.
Right. It is a strategic retreat.
It is. The FCA's guiding philosophy for wholesale markets is shifting back to replacing heavy prescriptions with outcomes and replacing preemptive checks with disclosures.
Which makes sense.
They saw the data. They realized that an overly cautious interpretation of the consumer duty by wholesale firms was causing them to hesitate in competing for international business. This consultation is designed to remove those unintended regulatory burdens.
If you're finding this useful, don't forget to follow Reg Talk UK on Spotify or subscribe on YouTube. It really helps us reach more banking professionals like you.
So getting back to the broader theme here.
Yes, we've been tracking how regulators are either retreating to their proper boundaries, like in wholesale markets, or hitting the limit of their legal power, like in motor finance. But what happens when a quasi-regulator completely ignores those boundaries and goes rogue?
You end up with a structural civil war.
Which brings us to the absolute wildest story of the week. Four major banks, Barclays, NatWest, Santander, and Vanquis, took the Financial Ombudsman Service, the FOS, to the High Court for a judicial review regarding historical lending complaints.
These were mainly around credit cards and overdrafts, yeah.
Exactly. And the banks won a massive victory.
It is a stark public warning for the ombudsman about jurisdictional overreach.
Let's look at the mechanism of what the FOS actually tried to pull off here. The standard time limit for a customer to bring a complaint is 6 years. The FOS tried to investigate complaints well past that 6-year window.
Yep.
To justify this, they claimed jurisdiction over the entire credit relationship a customer had with a bank, citing a completely novel concept they invented called collective responsibility for unfairness.
Right. If we look at the mechanics, they were essentially arguing that even if a specific action, say a credit limit increase from 10 years ago, was legally out of time for a complaint, they could still investigate it because the overall cumulative relationship between the lender and the borrower over a 15-year period was somehow unfair.
That is just wild to me. Going back to analogies, that is like being sued for a bad meal you served a customer a decade ago. Not because the meal itself breached a contract today, but because the customer suddenly decided their entire culinary relationship with your restaurant over the last 15 years was unfair, and therefore the 10-year-old meal is suddenly actionable again.
And the High Court judge completely dismantled that logic.
Certainly.
The judge ruled that claiming jurisdiction for the whole of the credit relationship and bypassing the limitation periods was a fundamental error of law.
But the absolute twist here, the thing that makes this unprecedented, is the FCA's role.
Yeah, this is the crazy part.
The FCA, the statutory regulator that writes the actual rules of the FOS is supposed to base its decisions on, intervened in the High Court case to oppose its own ombudsman.
They did.
The FCA formally called the FOS's new interpretation irrational and procedurally unfair. Why would the FCA attack its own dispute resolution service in open court?
Because it threatens the entire constitutional architecture of financial regulation. The FOS was set up to be an informal, fast alternative to the courts.
Right.
It's designed to resolve individual complaints based on what is fair and reasonable, but crucially, within the framework of the law and FCA rules. The FOS is supposed to be subjective on fairness, but objective on the legal perimeter.
But they started acting like a regulator.
Exactly. Over time, the FOS has increasingly acted as a quasi-regulator. By ignoring this 6-year limitation period and creating a new concept like collective responsibility, the FOS was effectively creating brand new conduct standards through individual decision.
Which is incredibly dangerous.
If the FOS becomes a shadow regulator, the market loses all legal certainty. Firms can't price risk if the rules are rewritten retroactively by an ombudsman.
The numbers presented in court prove why the banks fought this so aggressively, too. Santander gave evidence that since the FOS adopted this collective responsibility approach, their historical lending complaints more than doubled.
Jumping from 31,000 to 71,000.
Exactly. It was opening the floodgates for claims that were legally dead.
This High Court ruling forcibly shuts those floodgates. The Finance and Leasing Association, the FLA, came out immediately to welcome the ruling.
I bet they did.
They demanded that FOS complaints strictly align with FCA rules to provide certainty. Because if lenders cannot rely on limitation periods, it creates a deeply unstable environment for credit pricing and investment in the UK.
Makes sense.
The FCA had to step in. They have to balance consumer protection with market competitiveness. When the FOS stretches its jurisdiction to rewrite history, the FCA has no choice but to defend the legal perimeter.
Okay, we have covered a massive amount of structural shifting today. Let's distill this down for the Monday morning commute. Can you summarize the week's biggest takeaways for our listeners in under a minute? Go.
All right. Number 1. Crypto firms. The FCA admits it cannot monitor you centrally. If you make over £10 million globally, you are now the FCA's £230 million surveillance arm. Prepare the off-platform telemetry for on-chain monitoring of linked wallets and draft unique disclosure documents for every asset by October 2027.
Number 2.
Number 2. Motor finance redress is completely frozen until at least late 2026 or 2027. Captive lenders are fighting on property rights grounds. Do not calculate or pay out redress, but keep your operational contingency plans warm because the backlog might end up at the FOS.
Right. Number 3.
Number 3, wholesale markets. You have a clear exemption from the consumer duty for non-UK business and out-of-scope activities like market making. Stop trying to prove a retail rule applies to sophisticated institutional counterparties.
And finally, number 4.
And number 4, the High Court, with the explicit backing of the FCA, just slapped down the FOS for jurisdictional overreach on historical lending. The 6-year limitation period holds firm, and collective responsibility is legally dead.
Spot on. So what does this all mean for you as a compliance professional? We started by talking about that X-ray machine, the desire for clean, binary regulatory lines and a powerful central authority.
And we end with a rather provocative thought for you to mull over this week. Look at the connecting thread across all 4 of these developments.
What's quite a thread.
The FCA openly admitting central surveillance in crypto is ineffective and outsourcing it to the private sector. The FCA's massive £9 billion redress scheme utterly stalled by industry tribunals. The FCA forcing a retreat on its flagship consumer duty in wholesale markets.
Yeah.
And the regulator literally going to the High Court to battle its own ombudsman over where the legal rules actually begin and end. Are we witnessing the absolute limits of centralized regulatory authority in the UK?
It's a compelling question. I mean, when a statutory regulator cannot monitor the new technology, cannot enforce historical redress without triggering years of litigation, and cannot even control the boundaries of its own dispute resolution service.
Well, it suggests that the architecture of UK financial regulation might need a fundamental ground-up redesign rather than just another policy statement.
The machine isn't just broken. We are hitting the limits of what the machine was ever designed to do.
That's all from us this week. Thanks for listening to Reg Talk UK. Until next time, stay sharp and stay compliant.